Hey everybody, welcome to the next episode of The Legal Notepad. Really excited you could join us. We recorded this episode completely different. We actually did a national webinar. We had attorneys tune in coast to coast, pretty much every state, and we covered this topic. How do you use a trust to preserve your client's benefits when you've resolved a case for them? Because it was a national webinar, we're making a podcast so you can listen to it on any of the platforms, but you can also go to the YouTube channel and actually watch the webinar. Really exciting stuff. Why don't we jump right in? Thanks for attending today.
Good day, and thank you for joining us for today's Seminar Web Live program, Using a Trust to Preserve Client Benefits After a Bodily Injury Settlement. Now, during our live program, silent attendance prompts will appear on your screen. These prompts are not active in the recorded version of the program. For the live seminar, these prompts may be required to earn CLE credit in your jurisdiction. So you will have approximately 15 seconds to respond to these prompts. You may also submit questions over the web throughout our program for our speakers by typing those into the Q&A section, and we will, in fact, I think they're going to address them throughout the presentation, but we'll also leave a little room at the end. So our speaking panel today includes Peter Wayne, Kevin Burke, and Robert Mattingly. And I'm going to go ahead and turn the call over to our speakers. And Rob, please go ahead.
My name's Rob Mattingly. I know the prompt there says Robert, but Rob Mattingly. I've been practicing law for about 26 years now. I handled thousands of cases, everything from car wrecks, products liability, med mal, all those things, mass torts. And I came up with doing this particular webinar because one of the things, as much experience as I have, that scares me to death is that I'm going to have a client, we're going to resolve the case, and I'm going to do something to lose their benefits. That always scares me. By working with Peter, who really does understand the stuff a lot better than I do, I've kind of learned when I need to watch for it. When I've got Medicare or Social Security disability, that being a different situation than when I have Medicaid or Social Security income, and when I need to watch out for these things. But I certainly don't ever want to cost a client their benefits, and it's really easy to make that mistake. So because it scares me, that's why I came up with this idea. Honestly, the way that Peter does it really narrows it down. It makes it easy to say, and what I want you to learn today is, when do I need to be on the lookout for it? And then when I need to be on the lookout and we have it, how do I go about setting it up? All of which is not hard if you know the kind of the elements to look for. Who do we have with me today? I have Kevin Burke. Kevin Burke works with us a lot in Kentucky. He's an appellate lawyer. When lawyers make mistakes, he goes and fixes them, is what I like to say about my good friend Kevin. So let's not make mistakes on this. Kevin, you want to say something briefly and then kick it over to Peter?
Yeah, I don't want to take up too much time because Peter's the star of the show. But like Rob said, I work with a lot of attorneys, personal injury attorneys, and that, and this is just a fascinating topic, and B, it's an area where you need people like Peter to tell you what you need to do and what you need to watch out for and that sort of thing. So with that, we'll turn it over to Peter.
Well, thanks, Kevin. Thanks, Matt, and Rob. So, the first thing I'd say is, if I'm the star of the show, Kevin, we're in for a pretty bad show. This is going to be a very disdisappointing.
Nope, you're the star, Peter.
But all kidding aside, our goal really, I think, Rob, you nailed it, is, there is a volume of information in the materials that have been provided for those that are participating today. We don't intend to get to all of it, right? And I think if we did, it would become overwhelming to a large degree. Our goal is to really give you a few things that you can sort of issue spot. If you take us back to law school to a degree, be able to say, what, those are the three things that I remember I need to at least inquire about. And if we get you to that place for the audience, I think we've done a pretty good job of trying to distill down what are roadblocks in the settlement process that we can try to help navigate. So, Kevin and Rob, as we go through this, I know you had mentioned, please, this is all about a dialogue, because I think as we, as a group, get the benefit for the audience to sort of hear the questions that you may have. And certainly as I go forth, please inquire as we go along, so that we're, the audience may have to wait to the end, but we get the benefit of discussing it as a group as we go along. So I look forward to the dialogue.
Hey, and Peter, and for the group, I'll monitor the chat and I'll watch. So if you have a question out there, send it in the chat. I'll monitor it, and we'll either answer it right then, or I'll tell you, hey, that's coming up in a few slides. So I'll monitor the chat. If you can go ahead and ask those as we go along, if you want. Go ahead, Peter.
Perfect. So as
everything will be in the Q&A, Rob.
Okay.
So Matt, if you want to go ahead and move to slide 7, I'm gonna jump around a little bit for the audience. I just think that in terms of the time, I want to make sure we get to and hit the high points. But as we work forward and get to the government benefits question, what are we doing on every particular case? So, if Kevin, you're helping an attorney fix their boo-boos, or Rob, you're trying to fix something that you've addressed in a client matter, what Rob is really trying to focus on is, all right, I've got a particular set of facts, and I've got a client who's been involved in an accident of some kind and is in the possession or soon to be in the possession of settlement proceeds. Or you've got a family member who is benefiting from a wrongful death litigation. Or you've got a scenario where maybe for many of you out there, you're not in personal injury litigation, but maybe you're out there in the world of doing estate planning or in some form of financial planning, whatever it is that might be the focus of your practice, understanding how various aspects of the receipt of dollars can impact your case. So the easiest example I can give you for today is Rob, because I think it's the one that is probably the most relevant to the audience. But Rob's got a case involving a personal injury individual. That person is on certain forms of government assistance. And now Rob's got to decide, what do I do with it? Well, I think the questions you want to be asking are, how much money ultimately, is at play? How much is the net going to be? What type of government assistance programs is that person on? What are the goals long term? As we look at it going forward, do we want to try to preserve the medical assistance program benefits that they're on? And or are there other aspects of planning? For example, maybe they would just as soon forego those benefits, but we need to make sure that we've identified what those benefits are so that, Rob, you can document your file appropriately to have said, hey, we talked about these things and my client made an informed decision to go in another direction, even though it may not have been what we recommend. But as you look sort of as a checklist of things, it really comes down to, what type of what is the settlement? Who are the beneficiaries of that settlement? What are their ages? And what are their government benefit programs that are applicable to that? And so when you look at government benefit programs, there are really two different types of program benefits in this country. There are what we call entitlement program benefits, and then there are means tested, or as I define, as needs based. So they're both, let's start with the government benefits that are entitlement based. Best example I can always give you is that Bill Gates is entitled to these program benefits, right? He worked into and paid into the Social Security tax system to be able to generate a benefit that was due to him. And that benefit can take 3 different forms. It can take either, early, the disability, early retirement, or what we would just retirement, right? And in that environment, his benefit is going to be dependent upon when he starts to elect to take those program benefits. And when they're going to take into 2 forms, it's going to be in the form of Social Security disability income. If you take it early, meaning prior to the age of retirement because of some form of disability, or you're going to wait to 62 and a half or whatever it is, 65, 67, and you're going to get those benefits in the form of income, in the form of old age and retirement benefits. But that benefit stream that is paid to you you're entitled to it based on your work history. For the disability side of that equation, it's also not just that you've reached a certain age limit, but that you've gotten to a place where you can't gainfully work. So when that happens, that's when you're going to become eligible for the SSDI benefit. Plus, after waiting a period of 30 months, you're going to then be eligible for Medicare benefits. Those are tied together. So let me pause there and see, Kevin and Rob, if you have any questions about the means test or the entitlement side.
Yeah, I'll jump in, and as I'll do from myself to remember things, I always say I dumb it down. But so under the entitlement section, because I think this is a real important slide for everybody. If you are getting a benefit that you're entitled to the benefit, then you're not probably going to have to worry about setting aside or doing the ABLE accounts. You're probably going to be okay to give your client the money. So if your client has worked their whole life and they are now retired and they're getting what most people call Social Security, they're not going to need these special trusts because that's an entitled benefit. They will not lose it if they get money. I always say the needs-based are are you at a poverty level where you're getting government assistance because of your poverty level? So this is not. And then Social Security disability, I call it SSD. You have it called SSDI. Is I paid in my whole life, but I was disabled. I got hurt. The government found me disabled, and all those benefits that I'm entitled to at 65, I'm getting them now, right? I'm getting them now. So I'm entitled to them. And I think a lot of people get SSDI and SSI mixed up. So that was kind of the point that I'm making. That is, I was going to get my retirement, but the government said I'm disabled, so I get it early. I get it at 47 because I can't work. And then once you qualify for SSD or SSDI in this case, later on, you get Medicare. That's also, so you're not going to mess up any of those benefits. So when my office sits down and looks, I go, are we getting Social Security or Social Security disability or Medicare? I'm okay. I don't need to call Peter. I don't need to worry about it.
With one caveat that I don't necessarily know if I want to go down this rabbit hole, but if you are on Medicare or have a reasonable expectation of being on Medicare in the future, meaning that you've got SSDI, right? You may have SSDI now, but not be eligible for Medicare just yet because of that period of time, that waiting period. If you're in that space, then and you settle a case involving Medicare, there's a federal statute called the Medicare Secondary Payer Act that does require you to at least assess whether or not Medicare has an interest in the settlement, both from a lien standpoint. So do they have a recovery for any monies expended from the time of settlement, or rather the time of injury to the time of settlement? And then they've also got what is that future cost of care component. Is Medicare have any right to the additional dollars that were paid to the individual on account of future injury-related medical assistance? That piece, I would just note, and if you're taking notes on this, is check that box and come back to that. But if you are settling a Medicare, a settlement involving a Medicare beneficiary, it is worth inquiring with institutions like ours, or there's a great organization called Medivest that is out there that can do great work and help you determine whether or not a Medicare set-aside is needed inside of that settlement. The benefits aren't going to be impacted by the receipt of the money. It's just that federal analysis as to whether or not any portion of that needs to be set aside, if you will, to contemplate future injury-related medical expenses. So just wanted to highlight that because it is a little bit of a nuance, but let me pause there again and see, Kevin or Rob, if you have any questions on that.
Peter, I had a question about so veterans benefits. Where does that play into this? And let's just say veterans disability benefits first and kind of work through it that way. Are those considered entitlement or needs-based?
Those are going to be entitlement benefits. I'm pointing up because it's at the top portion of the slide. So Kevin, absolutely going to be based on an entitlement. So think of, many people that are on VA benefits are also going to be like receiving TRICARE. There's a consensus between those. TRICARE is going to have a similar link to Medicare. It's going to have to be analyzed for any dollars expended from time of injury to time of settlement. It does not have any future cost component to it. But it is there is going to always be that analysis as to does it have an interest as a lien against the settlement proceeds. But on a going forward basis, there's no worry about the impact of handing, say, for example, your client a check and it negatively impacting those VA benefits going forward. There are some nuances. So to the way in which you can become eligible for certain long-term benefits under VA, I'm not as familiar with those, Kevin, and those can be somewhat nuanced in terms of how they apply when you have a settlement. So I think for anybody on the audience, if you have a VA beneficiary, know you're going to fall into the entitlement analysis. But I do think probably talking to a VA specialist is probably warranted just to give yourself familiarity with what that particular settlement's doing for your client.
So to kind of bring us back, and Peter, in the personal injury world, our listeners are going to be real familiar with paying back Medicare out of a settlement. That's different seminars are very, very familiar. They're going to be very familiar with, I like to say getting around the Medicare set aside provisions for future because, we've all been doing that. But when you're making your checklist for this seminar, with those caveats, SSD, Social Security, Medicare, you're probably not going to be dealing with the trust or the ABLE accounts that we're getting ready to talk about.
That's correct.
So then you're going to say to those listening, okay, what if I have these need-based, meaning my client's essentially poor and they get these other benefits? And why don't you move on and talk about those there?
Yeah, perfect. So when you think of needs-based benefits or means-tested benefits, they're really I've always said Medicare is suffers from the worst marketing campaign of all time, because when you think of Medicaid, generally people think maybe it's a benefit afforded to certain portions of our society that that may not be motivated, or whatever the case may be. And in fact, really the benefit there is really focused on elderly, children, and the disabled. So it's a core piece of the underlying fabric of how we provide medical assistance to some of the most vulnerable in our society. And Rob, you've experienced this a lot, right? Unfortunately, a lot of those people do run into cases and scenarios where they get injured and they've got to navigate what to do with the money. So how do you know what to do with it once you have that analysis of they're on SSI and Medicaid? Well, first, how do you know if they're on it? One of the earliest and most easiest ways to define that is if you have a client who comes and says this year they're receiving $967 in benefits, probably they're more than likely on SSI benefit, because that is the maximum amount of money that you can receive under the SSI program in 2025. So that's part one. If they're receiving over that amount, they're not on SSI, because you can't get over it. So if you're, say, for example, you got a client that's receiving $900 a month, or rather $1,000 a month, then Rob and Kevin, you're in an SSDI world because of the fact that it's in excess of that SSI benefit. On the flip side, if you've got 967 or below, there probably is a pretty good chance that they may be on that SSI benefit. And so you're going to want to analyze what type of assistance they're on. In each state, because it's a federal benefit, but it's administered by the state, is going to have its own set of rules. But for the most part, most states are going to be what we call 529, or not 529. I think it's 209B states. I think I may have that wrong, but there's a federal statute in most states that allow for, so long as you receive $1 of SSI, you're going to automatically be enrolled in Medicaid. And that is, at least for Kevin, Rob, we all are in Kentucky. That is true in Kentucky. So you actually never apply for medical benefits through Medicaid. You actually apply for the benefits that are available to somebody through the SSI program. And so long as they get $1, then they're automatically in that Medicaid benefit. So then you ask yourself, I think, Rob, the question that is a good one, which is, all right, well, what do you do with it once you know you're on medical benefits that are Medicaid oriented and they have the SSI benefit? What is the test to determine how they keep those? Those program benefits are generally predicated on a $2,000 asset threshold, meaning they can have no more than $2,000 at any given time, and they cannot receive any more than $967 in benefits. Any dollar they receive in income that is in excess of that 967 would kick them off. So even if you say, for example, Rob, we've had the benefit of doing a structure. Say, oh, you know what, I don't want to do. I'll just replace or try to add to this income benefit. They're getting 967. What actually happens is you just take the income and you're replacing dollar for dollar the SSI benefit they're already getting. So you're not actually moving the needle at all. You're not giving them a benefit. You're just replacing a settlement dollar, rather a Medicaid or SSI dollar rather, with a settlement dollar. So the reality of that is there are planning strategies that can allow for them to maintain their eligibility for the SSI and Medicaid, in addition to benefiting from the actual settlement dollars that you're receiving or that you've negotiated for them. So if you could go, Matt, to the next slide, we'll talk a little bit about that.
Hey, before you move into that next slide, let me make sure we've got that, because I think that's important, because I tried to do that once, outsmart myself, and Peter's obviously stopped me. So under needs based on this slide, if you've got a client and they're receiving any of the benefits under need based, so this is the slide you keep set aside, you're probably going to need to do one of these trust or able trust, special needs trust, whatever it is. You're probably going to need to do one of those to not lose the benefits. Is that right? Or at least you have to.
The benefits that with the programs or the tools that we're about to talk about are primarily affecting the means tested analysis, right? Because the entitlement side, we're not worried about it.
That's right.
We can do things, right? We can, but we don't have to. Under the means tested analysis, it is important that we talk about able accounts and special needs trust, which are going to be at the core of what we go for and talk about.
And then the idea that I once tried, and you corrected for me, is, okay, well, look, if they can only get $900 something a month, why don't I set up a structure? I'll pay that into it, and then they won't go over. And you correctly pointed out, well, no, they're going to take that dollar away from from what they're already getting, so they're going to lose it dollar for dollar. So that mechanism, because a lot of people on here probably use structure settlements, that mechanism for these need-based things that we're talking about, it does not work. You can't do that.
I want to highlight two things. One is that doesn't eliminate structures at all. It just we have to be thoughtful about how we set up the structure so that it pays into the trust that we're about to talk about.
You can pay the structure into the trust, but not directly to the client.
You got it. Yeah, and I'll highlight that in the coming slides. The other fact I just want to highlight for the audience is that I'm glad you're highlighting the slide that has two errors on it. So that's always a good thing to highlight right away. As Kevin, Matt, Rob, we're all looking at this, and I'm looking at all I see are the two errors that are glaring at me. So for the audience, our attention to detail in planning is better than our slide production. But I'm grateful for the patience everybody's given me on that end. So.
All right, Peter, take us to the next point. What do we do once we decide of those things?
So, I think actually as we go forth, this is the next slide is really talking about Medicaid and sort of how it works. So, Matt, if you would go to the next slide, that'd be great. Next, please. Next. There we go. Perfect. This is slide 11, I believe. So in this particular slide, we really talk about that Medicare, that no preservation planning is needed for Medicare or SSDI, because again, those are entitlement programs. But under Medicaid and supplemental security income, where we have a $2,000 asset threshold plus an income threshold that is generally tied to the SSI benefit, we're going to look at 4 different strategies. They're going to be an ABLE account, which I'll talk about, which is really a checking account that was established under the Obama administration in 2014, effectively to try to create a mechanism where individuals with certain levels of disability at certain ages were able to sort of to have some ability to preserve income over the course of their lifetime. Prior to the development of ABLE accounts, any point that they had excess of $2,000, these individuals would lose all the money and ultimately, or their eligibility for the program. And Rob and Kevin, it created a real stress for guardians and conservators because every month they'd get a check and then they'd have to go and figure out, all right, we got to spend it because if any of that money rolls into the next month, I've now got a scenario where I may be in excess of that $2,000 threshold. And my, the fiduciary, the person I'm trying to care for, or my child or aunt or whomever it is that is the beneficiary of those program benefits, they may run into issues. So that was the core of why ABLE was established, was really to kind of create a mechanism, if you will, a checking account solution to be able to create some level of year-over-year savings for individuals with forms of disability. The first party special needs trust comes in 2 different forms. It's going to be either a pooled or a private. That's a longer term strategy, I think, in terms of where you can set up these vehicles as a mechanism by which we try to, Rob, we've done it many times where settlements and lump sums of excess of certain amounts are going to be placed into one of these 2 vehicles that I'll talk about in a second. Or in some scenarios, you might actually have not only an individual, let's just take a child, for example. I think it's a good time to maybe use an example. So, Rob, if you had parents and there was let's say it was a medical malpractice case and the child was, the age of, during the birth process, unfortunate circumstances occurred. And as a result, that child has got significant injuries, right? And you litigate the case and ultimately get a settlement. Say that settlement is, in excess of $1 million. We're going to be looking at it from the first party trust scenario because that beneficiary now has got a right to certain assets that if they take possession of it, they're going to be in excess of that $2,000 threshold. And now we've eliminated the Medicaid benefit that is so critical to them. Many times, also I think it's important to highlight is that Medicaid benefits can come in the form of just traditional medical assistance, like an insurance card. But there's a certain subset of individuals out there that are going to be on what they call Medicaid waiver programs. So for any of you all out there that are on, have a client that says they're on the Michelle P waiver or the home and community-based waiver or the brain injury waiver, these are additional Medicaid program benefits that are afforded to certain individuals with certain categorization of disabilities that is going to essentially receive like a block grant. The government is going to say, we're going to allow for X number of dollars to be provided to this child on a recurring basis to augment their care, to live in the community, to live in an assisted living facility, whatever the case may be. And that Medicaid waiver program is vital to their long-term stability. I say that and I highlight that here because if we don't do the planning and we just say they were on these benefits and you gave them a check, Rob, they would lose the SSI, they'd lose the Medicaid, but they also lose that waiver. And that waiver benefit program sometimes have a waiting list of 10 years. No kidding. And so,
yeah, and I think that's real important because when I lose sleep over some of these things, in the past, it's really been for the waivers. I mean, I don't want to mess any of the benefits up, but the waivers are just a massive amount of lifetime money that's going to go, and care that's going to go to these very needy, deserving clients. What were those again? Can you say those? I just want people to make sure that
Yeah, sure. So in Kentucky, it's Michelle P.
Yep.
Michelle P. waiver. It's the home and community-based waiver. There's the brain injury waiver that it does, and the supports for community living waiver. Those are the four that are immediately coming to mind. Those Michelle P. is a Kentucky one, but the rest of them should be fairly consistent across across the country in some form. But certainly, if you've got an individual on Medicaid, I mean, I talk with your, if you've got an attorney that you work with in your region that is somebody who specializes in special needs planning, it's not a bad time to maybe draw attention. There's an organization called the Special Needs Alliance that has attorneys across the country, generally 2 to 3 in each state, that are honed in on this. So if you're on the call and you're looking for a resource, that's a great spot. Obviously, our organization does a lot of great work in this space, and happy to take calls. So if you got this Medicaid thing and it's giving you anxiety like it does Rob, there are partners out there that can absolutely help you navigate this, and then analyze, as you look at the full 4 bullet points at the bottom, what part of or each of these might be the way to proceed.
And Peter, if our listeners, if they get to the point, which I've done numerous times, where I'm just not 100% certain, I've sent Peter documents. I was like, here's my client's card, here's a monthly check, here's the award letter, tell my clients to gather it. And I've sent them to Peter and said, where do these fall? Because I'm not sure. And I think people can reach out to you if they want to do that. And that's in the space that you're very familiar with. But feel free to use that, because I've done it a lot and I don't know all of them. So
yes. Yeah. So let's circle back to the example I was giving you. Again, Rob, you're settling a case involving a minor that was injured during the birthing process, and we have to set up a first-party special needs trust. That's because, the settlement is the minor's money, and the way that they would view that from a Medicaid SSI standpoint is the minor's assets, which would be over that $2,000 threshold. But the government allows for us to set up these first-party special needs trusts, which, again, I'll get into the details of what they are in a little bit in the later slides. But for the example purposes, we would set up this trust to insulate these settlement dollars from negatively impacting that minor's eligibility for SSI and Medicaid. What we don't see a lot of times is the continuation of that planning strategy to focus on mom and dad. Because ultimately we set this all perfectly up, and the child's on, medical assistance through Medicaid, and they have SSI, and maybe they have a waiver, and they set up this first party trust, and it's great. Mom and dad are continuing to live their lives and caring for their child, and mom and dad both pass away. And mom and dad have done no planning. Well, now that child is the inheriting party of assets from mom and dad that are now going to be their assets. And so by that transaction of generational wealth transfer, we may now have negated the very planning that we focus so hard on over here during the settlement planning process, without bolstering it with an estate planning component to that. So if you have anybody on the call who's got a beneficiary with parents who've got resources, it's vital that you not only think about the planning that you're doing for the child or for the individual, but are there any other avenues for which that child or that individual may receive assets at some point during the course of their lifetime? If they are, then an additional strategy is to allow for mom and dad to set up what is called a third-party special needs trust, where they direct their assets into a trust that is insulated from counting against the program benefits their child is receiving, and would then augment their care, similar to a first-party trust, but it's set up by mom and dad as opposed for the direct benefit of that or by that individual or their fiduciary. So let me pause there. There's a little nuance. I'll get to it a little later, but I want to make sure I highlight that moment as we go down the slide here.
Peter, in your example, so the client, the minor's getting a bunch of money, but we've got to would they have both a special needs, a first party trust? So you'd set up a first party trust. I would have you do it because it's too much for me, but you have first party trust. And then we're talking to the parents saying, what's your, financial situation? What's your child going to get? And you may also have a third party, like you would have 2 trusts set up.
100%. And then to pull it all together, you may have an ABLE account in addition to the first party and the third party trust, as a vehicle by which you're going to be able to provide effective assistance to that disabled person to give them some level of autonomy.
And we're going
because
to talk about able accounts in a few minutes, right? Like I literally just set one up with your help. This week we're finalizing it, so
correct.
you'll talk about that. Okay. Good.
Yep. So I think it's a good opportunity. So, Matt, if you could go to slide 12, please. I think it's the next slide, actually. 12 and 13, maybe the next one. There you go. All right. So as I talked about before, able accounts are really, they're checking accounts with some restrictions on it. So when you think of able accounts, they are checking accounts that are set up for the sole benefit of helping a disabled person. Generally, that person has to be disabled prior to the age of 26. And you can put $19,000 a year into that slide by virtue of the fact that the law that was set up is tied to the gift tax exemption. So whatever the gift tax exemption continues to increase, the amount of money that can be deposited into this able account is going to correlate to that. So right now at $19,000, you can put $19,000 a year into this account. You may ask yourself, well, why this vehicle versus a trust, for example? Well, I'm going to say that this one doesn't cost you anything. It's just a checking account, so long as you establish it with the right providers, which we'll get to in a second. And then once you set it up, the money that is in that particular account is going to be able to be provided in for really anything that individual may need. So housing related expenses, medical expenses, treatments, therapies, education, travel, whatever it is, by and large, you're going to be able to, pay for it from this particular account. And the beauty is you're not going to some trustee for that. You've got some level of autonomy by either giving the individual themselves or their fiduciary an ability to go and utilize certain resources to augment their quality of life with this vehicle. The important thing, too, to note is that when they set this up, you may notice this was actually set up under the 529 rules. So you may ask yourself, well, that's interesting because 529 are how I say it for college. How does that have to do with disability? I would have to go back and look specifically, but I do think that there is the benefit of the fact that the administrative body that oversees and audits this sort of arrangement is the IRS, not the Social Security Administration. When we get to trusts, that's under the purview of the Social Security Administration. This is under the purview of the IRS, which means the IRS doesn't know what to do with it. And so their auditing, the oversight is much less. Now, does that mean that you can do at will? No, but it does mean that, the oversight is just less substantial. So I think this is a good way of being able to provide some autonomy to folks in an environment that is maybe a little bit less questioned than you will with the first party special needs trust arrangement. So let me pause again and see, Rob, Kevin, if you have any questions.
I don't have any questions, but I might make a comment. I'm setting up an able account now. For the listeners, I've got one where a kid's not getting much money. They were getting $30-something thousand. It was a small car wreck. But I didn't want to lose the benefits because they are getting the SSI and the Medicaid, and I just didn't want to mess those benefits up, even over that smaller amount. That was their share after a bunch of different things. So, Peter gives me the website. I go to the website to able accounts. He emailed it to me. It's all set up. We do it. There's not even a real fee for anybody to do that. The able account charges just a little bit, but not much. It's real easy. You go online, you fill out the forms. You put the money in. In my case, there was a form I filed with the court. So, how do you go about doing this? Peter gave me the forms that I filed with my probate judge on my guardianship and said, "Hey, judge, we're getting this. We want to put in an able account. Here's why." The judge signs off on it. And in that case, they're letting us put in the $19,000 the first year. So we're getting ready to put in $19,000. They're letting me hold the rest of it, which is just under it's 40. Just under 40 total. So it's less than 19. Hold it in my escrow to the first week of January and then dump the rest of it in next year. Judge signs off on the order and we're all done. It didn't take a lot of time. So it's not real hard is the point that I'm making. And it's really effective in those kind of cases. Sorry, Peter, go ahead and comment as you.
No, I think that your real world examples are great. And, I think, if you would, Matt, go to slide 18, if you will, because it's going to give us a little bit of clarity as to maybe where you can go to find more information. I think one more, maybe two more. But there we go. All right. So where can you establish it? Well, there's able. That first link below is to a national resource where you can go and see all the various able accounts that are available throughout the country, and you can even begin to compare why one is maybe better than the other. So And you're not obligated to just choose the able account in your particular state. You're free to choose and select as you wish. But I would say that vast majority of them fall underneath what are called stables. So Kentucky is a version of this. We use the stable account program, which is actually run through the Ohio Department of Revenue. So the Ohio Department of Revenue set up the stable program as a mechanism to try and help support other states' implementation of this particular benefit made to disabled folks. So, a simple Google search can find you your local solution wherever. If you're in New Mexico, California, Maine, Vermont, or Florida, there's an answer for you at each of all 50 states. But that first link may be valuable as you evaluate where to go.
Yeah, and so they don't miss out. This, when I look at this slide, you put Tennessee, Florida, Ohio on there, but we looked at before it started kind of the different states our participants are in, and they're all from all over the country. You can do this all over the country. You just got to get to the right spot through the website.
That's right.
Yeah.
So I think, the important thing is, all right, so now we've covered able accounts, right? Now, what does that mean in terms of the other resources that we've talked about, the first party trust? Why an able account versus a trust, or why a trust versus an able account? Well, I think, Rob, you nailed it when we talked about the threshold that you navigated with. In your case, obviously the numbers worked out, but if you've got say, for example, a $50,000, $60,000, $70,000 and above net to client, it's going to create a mechanism where it's challenging to use the able account because of the fact that you've got to hold those funds for so long. And so in that particular set of facts, because of the $19,000 threshold cap on these accounts presently, we may not want to evaluate that particular solution exclusively. We may look at what is a special needs trust. So if you want to go to slide 22. This is a form of, there are two different types of first party special needs trusts. So we get here again, just reinforce it. We got here because we have a settlement or an inheritance, Kevin, for those out there that are not, in the personal injury world, that is going to be in excess of that $19,000 threshold. Now, before I move on real quickly, I want to make one other comment. You might ask yourself, okay, there's a $19,000 annual limitation. Is there any gross limitation? Meaning, if I put $19,000 a year, is there a ceiling on how big the account can get? Or could my client, could my son, could my daughter, whomever, could they have, $200,000 in that account? And unfortunately, the case is no. If they're on SSI benefits, if they're on a means tested program benefit, they're going to be capped at $100,000. So $19,000 a year into that account on an annualized basis, $100,000 gross amount in terms of the valuation of that account in total. If you're setting up an account for somebody on SSDI and Medicare, meaning they're not on a means tested program, then that threshold jumps up to the limitation in your state for 529 accounts. I think in Kentucky, it's like 350 some thousand. But for these purposes, I think the takeaway for everybody in the audience is I have a $19,000 annual exclusion. I have a $100,000 ceiling. I think those are it's easier just to say, okay, I can do $19,000 or $100,000 over a period of time, but I can't ever give above that $100,000. If you've got a settlement where, you're, let's just say 50,000, 60,000 and above, then you're in a world where the able account's not an option. So you're going to look at saying, all right, well, I can't give this money to my client because, again, they're on a form of government assistance and it's means tested and I'm going to negate their benefits. So I'm going to look at two different options. And those options are set up under federal statutes. So the statutory reference is 42 USC 1396 PD4A and C. A is the private trust. And Rob, I would say that generally speaking, when your larger settlements, what I'd say, if you're going to have net to client in excess of, say, $1 million, you're going to fall into this, the first party scenario. If you've got less than 100 or less than $1 million, you probably want to consider whether or not the D4C trust, which is a pooled trust solution, is good for you. Now, let's talk about the differences between the two. In the D4A world, we're going to go and work with an attorney. We work with, individuals that are part of generally two organizations, either NAILA or Special Needs Alliance, that have an expertise in drafting these types of trusts, but they can be set up by the person themselves, grandparent, parent, guardian of the court. And once they set these up, they are for their own sole benefit, and meaning the assets can only be distributed for their benefit, no one else's. And the individual setting it up, or for the beneficiary, if it's somebody's doing it for them, they have to be under the age of 65. And so those two restrictions, meaning, who's setting it up and the age of 65 is important. And then Rob, as anything, there's always we'll give a little bit, we got a little taketh. There is a rule that says, okay, once this trust is funded, we'll let you get SSI, we'll let you take and maintain your Medicaid. However, on the back end, if there's anything that's left in that trust at the individual's death, Medicaid is going to have a right of recovery against those dollars for any amount expended on behalf of that individual during their lifetime. So again, but we get to choose the drafting attorney, who's the trustee, who's the investment manager, no different than any other type of trust that you would set up in for healthy individuals or for charitable planning purposes and the like. Does that Rob? Am I making that distinction clear?
Yeah, very clear. And a lot of times we sit down with clients, because generally, the guardian of the very disabled client generally, and we're like, look, these are all the things you can spend on these trusts, and it's a lot. At their passing, the beneficiary's passing, the government's going to take these benefits. So, think about spending it. Like, think about using it. Make their life easier. Make their life more enjoyable. Like, don't leave this here for when they pass away. It's always tough because you don't want to, you don't necessarily want to blow it all before their life is over, but you also want them to use the funds. And I think guardians like to hear that, like, try to use some of this. Peter, I know, or Kevin, I don't know what your all's thoughts on that, but that's the conversations I often have.
No, I think in the planning space, Rob, so, if Forge Consulting is doing the planning piece, we oftentimes use our trust company called Advocacy Trust to do this work, because if we have 600 accounts, I would say probably 250 of them involve special needs scenarios. And we know those are spend down accounts. They're not generational wealth accumulation vehicles. The sole purpose here is to give the highest quality of life we can to an individual who's been through a really unfortunate set of facts. So our goal is to try to spend it as much as we can, because the best thing we could do is that individual dies holding on to the last penny as they pass away. And because anything else is just going to go back to the state potentially. And that's not for most individuals, that's not the desired outcome.
Right.
So in that private sector, though, again, million and above, we're going to get control over trustee, the trust attorney, and the investment manager. When you have, say, under $100,000 or $1 million, you might fall into a category where the fees that are associated with private trust administration just may be too high. It may not make economic sense. So if you got a $300,000 trust, and that the annual fee for administration is $6,000, that's a pretty hefty fee. I think that's, doing quick math, I think that's 2%. So the federal statute allowed for nonprofit organizations to be established to be able to administer special needs trusts. And that effectively is their charitable enterprise, right? That nonprofit's sole purpose is to run a special needs trust. Now, I'd be remiss if I didn't notice or if I didn't highlight the fact that these nonprofit associations haven't had the greatest track record at points. There have been, unfortunately, some unfortunate certain individuals who've taken advantage of sort of the disabled nature of the beneficiaries that are involved. If you do a quick Google search, you could see the Centers for Special Needs Trust Administration down in Florida. It's unfortunately, I'm not going to belabor it, but it's a pretty, it's just a really disappointing set of facts involved in that case, where dollars that were placed into a trust were ultimately potentially, or at least the accusation is they were misused and mismanaged and all sorts of things, so that it left a lot of individuals without the access to the funds that they put into it. I highlight that because, yes, there are bad actors, but that isn't the industry as a whole. There are ways to make sure that you go to and work with a pooled trust service provider who's doing great work. And how do you do that? Well, they're not regulated entities. These are nonprofits. So you have to work with somebody who's doing private assessments as to, do they custody their own assets, and does somebody else invest them for them? And do they get an audit, maybe say every year, every 18 months, 2 years? I think those are the big three. Whenever you're going through, if you're going to go down the pooled trust arrangement, make sure you're asking the questions as to, okay, who is this institution? What's their track record? And is there anybody independent of them that can vouch for the sort of the nature of their business and the safety of its operation? I think that's really important, just because of some of the historical legacy issues that have been raised in the past. Again, I'll pause there and see if you and Kevin, I don't want to keep talking if you've got questions.
I don't mind jumping in again, just the outlining side of me. We talked about able accounts and the $19,000 a year, although the clients can really use the money, and those are great mechanisms for your not real big cases, but preserve your benefits. Boom. Then we moved on to these trusts. And then very broad sense, you got the private trust that's just going to be your client's money in that trust, overseen by the trustee and the financial providers that you choose. But those fees can be higher. So you want a large amount of money in that. There's nothing magic about $1 million, but if they're going to be getting 1 or 2% a year, you want a lot of money so you don't blow all through it with that. Then, if you're not getting quite as much money, then you say, well, maybe a pooled trust where we put my client's money in with everybody else's money. The fees are a lot lower, so we're not going to blow through it in fees, right? But you don't have quite as much say because it is going to have its own trustee and its own people financially,
You got it.
et cetera. And those are what you're deciding. You decide, do I got to do something to preserve my client's benefits? Yes or no? We talked about that. And if I got to preserve them, which of these mechanisms is best for this particular client? As much as I know about it, I would still call someone like Peter because it is a lot. But I would also give you this. It's not hard to set them up. I worried when I first started doing this, like, how hard is it to set it up? What orders? You get the forms, you file them, the judge signs them, it's set up, and your clients are off and running. And then they have somebody from the trust advising them on benefits and stuff they can spend. So it's not as overwhelming as it seems. Although as a practitioner, and maybe for no one else on here, but as a practitioner doing it, until I got used to it, it seemed overwhelming. But it's really not. Sorry, Peter, Kevin, anything you got?
So I think as we kind of move, if you could go to slide 26, Matt, that would be great. Make sure we're perfect. All right. So when you look at the distinction between these two, you might ask yourself, okay, well, what is the investment strategy, right? If I'm going to set up a trust for somebody, what are some of the things that I need to be aware of? Obviously, the rules to making sure you set it up right are key. Rob, I think you highlighted a great thing that if you're not doing this with some form of regularity, it can be a daunting task. I think you've done it enough to feel some level of comfort. But I would say that for anybody on the call, when you're engaging an attorney to help draft, if you're doing a private or working with a nonprofit that's setting up the trust, just bear in mind they're going to see supporting you in the petitioning process if you've got a minor or an incompetent individual to ensure that the proper court documentation is secured to get these things approved. If you're not getting that level of service, meaning drafting through the court process, I would give yourself a moment of caution to say, okay, make sure you're with the right partner, because they really should, from soup to nuts, be able to help you, navigate the establishment of that trust, not only from a drafting standpoint, but the court approval process. And then as you get forward and actually have it up, then you got to make sure you're working with a trustee who understands what their obligations are to the beneficiary. And I think this is probably where the biggest dialogue happens with the client, right? Because most of this stuff's going to go over their head to some degree. They're going to hear, all right, I got to set up this vehicle because I got to preserve my Medicaid, but how do I get access to the funds and what can I do with it? And I think this is where, when we talk about under slide 28, Matt, you don't need to go there just yet, but it talks about finding a trustee. And this is, I think, the most critical part. In the nonprofit world, right, they should be fairly astute at this because this is their sole purpose. In the trustee world, I do think that finding a corporate trustee in this particular space makes a lot of sense. There are a lot of trust planning I could tell you that does not need a corporate entity, but here you do, because you're paying somebody for the expertise of understanding when and how to make distributions. What can they do and how do they use that money? And I'm going to use some examples. So one of them is, physical rehabs, medical, educational, trips, supports at the home, how to buy a home, how to fix a home, how to buy a car, how to change that car, maybe for the needs of the special needs individual. But I think the other two pieces is if you find a trustee who's got some comfort in this, they're also going to be able to find different ways to help create some level of autonomy. And I think that's that autonomy piece that is so valuable as you try to create a mechanism to create stability and long-term success. And they do that under two ways. One of them, and I'll just speak from us, we use a thing called a TrueLink card. So in the trust planning world, for those on the call, the trustee is now going to have possession of it. So it was us, Rob, we have a client of yours and say it's a minor beneficiary and we're administering that trust for their benefit. We know that we can only disperse money for their sole benefit. If they wanted to go and say, take a trip to, Disney World, we would be able to help support that trip by paying for the travel expenditures as well as the hotel room. And more than likely, because they may not be able to go on their own, we would be able to pay for an accompanying parent or sibling or whomever to make sure that they go and they're in a safe environment. So there is a mechanism by which we're going to approve of some of those decisions. However, those are bigger ticket items like cars and vehicles and trips. Well, what about if the child just needs to go to the routine store to, buy diapers or buy formula or buy anything that can help that individual? It's kind of a pain to have to coordinate that with regularity with the trustee. In these ABLE account, rather, the TrueLink card is a vehicle that allows the trustee on our end to give the beneficiary or their guardian a debit card that is tied to the account. But we control the volume of assets that are made available on it at any given time that can reduce the risk associated with that money being mismanaged. The other thing, Rob and Kevin, is that money can never be pulled out. Like, you can't go to an ATM and pull cash out. It's got to be used in like a transaction orientation. So you could go to Walmart and buy formula and other items, but we also can control what they buy. So we can say no to alcohol, no to tobacco, but there's a whole litany of things that we can approve. It creates some guardrails around that autonomy that we're trying to develop with the family. And we have found that is an incredibly successful mechanism, being able to create the use of the trust, Rob and Kevin, in a way that actually make sure they're spending it, but that the beneficiary ultimately gets the benefit of the money as well. So that's a huge piece.
And what I like about it is, because once I've got it all set up, I am generally, I'm generally out of the picture at that point in time. I've set it up. I've done good work for my client. They are happy. I've introduced them to the trustee. I'm done. But I also know that they can only spend the funds on certain things. It's broad, but only certain things. And there is a trustee that through this trust that knows what they can spend it on, because ultimately if the trust is audited or whatever it may be, to make sure they're not spending it on things that would, because they could still lose their benefits if it's not going to those things. It's all taken care of. The card won't let them buy tobacco. The card won't let them, the things that might disqualify them. And I don't have to worry about it. It's all done. And the trustees are taking care of the accounting and all that stuff. So to me, that works out well. But the conversation that always happens every time when we go to set it up is, Rob, what do I get to spend this money on? Like, no one wants to put it in there until they know what they can spend it. Fair question. And it's very broad. Like, you can use it for a lot of things. Sorry, Peter, go ahead.
No, I think this is great. So two things. So how do you know if, Kevin can answer, how do you know when an attorney has done a good job? Well, they don't have to hire Kevin. How do we know we've done a good job is, Rob, you never get a phone call from your client again. And not to say that you haven't done a great job, but we internally honestly do sort of evaluate our ability to be successful is if you never have to talk to your client again, other than maybe it's a personal connection you have, then we've done our job right. Not to say that we haven't done our job right and still you get a call sometimes, that happens, but there are, certain metrics that we try to hold ourselves accountable for, is that we should be able to figure out most of the solutions for that needs. And Rob, I promise you, I think that probably the most consistent two things that people ask for immediately upon funding of a trust, whether it's pooled or private, I'm gonna let you and Kevin guess. What are the two items that you think they're most regularly the first out of the door? What are the two items?
I get, what can I spend it on? That's what I get.
Okay, but if you had to drill down a little further, what are the two items they want to spend it on?
Car.
And
a house.
Yeah, bingo. Yeah, and
those are the questions that I tend to get. So yeah.
All right. So if you could go to slide 32, Matt, that'd be great.
And the car usually is broken down to, to be real honest, is broken down to some type of transportation for someone that's in a wheelchair. It's often a special needs kind of vehicle that they can't otherwise afford. So it's not just go blow it on a car. It's I need to get my child around in this wheelchair,
And you'll see in slide 35 that we actually addressed that particular issue. So back one more slide. I apologize. I must be off of my numbers a little bit. So there you go. All right. So our job, honestly, Rob, is so often as a trustee is to make sure that we not only administer the trust right, but we don't put people in a position where they're going to fail. And there's a pretty heavy portion of our society, of our demographic that we serve, that have never owned a home before. So they get a chunk of money put into this trust, and it's generally been years of stress and anxiety to get to that point. And they oftentimes have got needs for that child that are critical. And if they can change their living situation and we can help them do that, then that is a huge win, right? If we can create, the most consistent, valuable thing I think we can give for individuals who are disabled or adults or children or adults, is a stable home environment. I mean, I think that is consistent throughout all forms of society. A stable home environment is our level of, have we been successful in doing our job? Which means we've also then got to go get the right home, right? If we have $1 million trust and they want to go buy $1 million home, well, we have failed, because they're going to immediately exhaust all their resources and have nothing to upkeep it and pay for taxes and all the things that come associated with that. So as an institution, we think that there's great value in helping our beneficiaries understand the home buying process, in having such a long history of redesigning or reformulating or rehabilitating is maybe the best word, homes to account for the needs of that disabled person. And so we have national, relationships that we get to leverage. And that's true. I highlight this for the trustee that you may want to work with. Ask the question of, not only are they familiar with administering a special needs trust, but are they familiar with buying homes and cars inside of those trusts for disabled individuals? Because it's a matter of being able to ensure that you continue to help those individuals maintain that property, which is now an asset of the trust, because it's going to maintain the level of living quality for that beneficiary. So you can find a lot of trustees, Rob, that don't want property inside of a trust because it's a liability, right? It's a risk. We, on the other hand, have viewed it as it's a part and parcel to what we do. We have to own that home because we're in the best position to help make sure that property is maintained properly. So I think our liability carrier would fuss at us all the time because they would love for us not to own property, but we understand that's the nature of our business. But being able to make sure that everything is done correctly is a huge part of that. And trying to determine what is the proper allocation of resources in a trust to be able to purchase that home. That's key. If you would go next to slide 34.
While they transition, Peter, we've got about 4 minutes left of us talking. Matt asked that we do the questions at the end. I'm seeing that we got 5 so far, and then we got 15 minutes for questions, and I want to make sure we directly answer all the questions. So you got about 4 minutes, and then we're going to directly answer every question that's in here.
Okay.
About 15 minutes.
All right, I'm gonna wrap up then. Matt, if you would go to the next one. I'm sorry. So, the cars are another example, right, Rob? Is we want to make sure you're buying a good car, that it's safe. What we've said is, you don't buy a Ferrari, but there are expenditures that can be reasonable. Rehabilitating a van the right way and knowing who to work with is critical. Those are questions, again, you want to ask your trustee. The other part is understanding, if you're a parent out there and you're providing care to your child and your child's disabled and has government assistance programs and this trust has been set up, oftentimes, Rob, the parent has to give up on their career potentially to care for the needs of their child. And we oftentimes work with an organization called Team Risk Management Services so that we actually, as a trust, can employ the parent, provide them income, let them build a 401k, and get health insurance all through this mechanism. But we do it through Team that offsets the risk so that the trust assets are not the primary employer, but that there are other forms of insurance that are in place should somebody get hurt at home during whatever care that it might be. So if you're out there as a practitioner thinking, gosh, I've got this $2 million settlement, $1 million is going into a trust for the beneficiary and my parents are destitute, there are ways that we can work the trust vehicle to be able to give support to that individual. And then as an added benefit is understanding how all of these accounts work together, whether it's ABLE, it's the Team Risk Management, it's the TrueLink card, pulling all of those pieces together. It's like a puzzle, and you put them all together in a way that I does think create a really great way to preserve the settlement proceeds in a way that lets them maintain Medicaid, lets them maintain their SSI, but benefit greatly from, Rob, the benefits that you've maybe secured or any attorneys have secured for them in the long term. So I think we've covered, at least at a high level, the primary focus of what we were trying to do, which was ABLE accounts, special needs trusts, in the various government assistance programs that are impacted by that style of planning. And with that, I'll hand it back to you and Kevin to answer or to ask questions as we go forward.
So I'll jump in real quick. We've got, I think, Matt, 15 minutes for questions. Right now, we've got 7 of them. We might knock out the shorter ones first. But the goal, Peter, right now, we got about a minute and a half, 2 minutes to try it. But I'd like to, per question, and I'd really like to get them directly answered as possible. Kevin, you want to read just one of them? We'll try to get to all of it.
Yeah, Peter. So one of the questions is, how do qualified settlement fund accounts factor into this? Do you ever advise clients to put settlements into a QSF before placing them into a special needs trust?
Yeah, that's a great question. So Rob, now you're making me stressed for the minute and a half that I've got. And I talk fast. The qualified settlement funds for everybody out there, they are actually underneath Treasury Regulation 1.468B. They're set up as a mechanism, primarily in the mass tort setting, Kevin, where you have, take for example, like Flip, Michigan, right? You have a bunch of minor children. They're going to be getting money as a kind of a settlement. That money's got to sit for a while claims are evaluated, and ultimately the determination of money is going to be made available to those minor children. That QSF allows for money to be paid from the defendant to this new institution that is its own taxable entity, and the defense gets a tax write-off. They get to walk away, and the people that are most instrumental in evaluating how best to make sure this money gets to the plaintiffs, that is now in play as part of that qualified settlement fund. So the question is, Kevin, if you've got a set of facts where you've got one or more claims, involving maybe you've got a car full of different families and they've all got settlements that need to be evaluated and medical benefits. Maybe that defendant says, you know what, I don't really care about any of that. I just want the release, but we don't want to forego the benefits that may be impacting if you put it in your trust account. Or we may want to preserve the right to structure some of that money and place those depository, those periodic payments into a trust later on. We can preserve all of those planning tools by putting it into a qualified settlement fund, which effectively through innovation replaces the defendant. And now you do planning and could do structures and do all of the things without defense's involvement. So I think for whoever the practitioner was, it's a great mechanism to buy time. If you're under stress and defense wants to get out of the case, it's a great vehicle because it's not going to negate any of the planning tools that we've talked about. It sort of takes us the stress off, and now we can do planning and ultimately then receive the money from the settlement fund as we design and get approved by a court.
Great.
Hey,
All right.
hey, Matt, let me ask Matt a question. Matt, are we a hard stop at 4:15, or if we don't mind to go a little bit long, can we make sure we get all these questions answered? Is it if we need to go a few minutes longer?
Yeah, absolutely. We could go a few minutes over.
Good, because I want everyone's questions to get answered. Go ahead, Kevin. With the next.
Well, yeah, and sort of so another question is we've been discussing SNTs in the context of disabled persons. To clarify, is an SNT available to someone who is not disabled but still receiving needs-based benefits? And this is in the context of survivors of sexual abuse.
And can you see them, Peter? Also, can you read them as we read them to you?
I cannot. I'm not unless I'm maybe. I mean, it might be view. I'm sure Matt could probably. Again,
if you just click on the Q&A button at the bottom of your Zoom toolbar, it'll give you a pop-up, and then you can check that out.
Okay, perfect.
This is the one from Lisa right now that we're answering.
Lisa, okay, got it. So it's interesting. So the answer to this question is whether or not they're eligible for disability benefits. It largely comes down to the question of whether or not they can perform substantial gainful employment. So, depending on the level of their disability, because it might be, emotional in nature, Kevin and Robert, it might just be that the incidents that occurred were so traumatic that it's creating some sort of emotional or mental disability to a degree. And I think, Lisa, in that set of facts, I think you'd easily qualify for government assistance in that space. The using of a special needs trust is absolutely still a vehicle that you could use in order to maintain their eligibility for means-tested programs. Whether or not the application of whether or not they're disabled is really a benefits question, not a special needs trust question. I don't have any issue with somebody setting up a special needs trust if you think it's sort of borderline or not, because you want to say, hey, I don't know if they're going to be eligible, but I want to go and give them every chance. So in advance of sort of applying for the benefit, we go ahead and set up the trust. I think that's absolutely reasonable and probably prudent, so that we don't go apply for it and they get negated because they've got too much money. So I think, Lisa, in that set of facts, I don't think that the nature of their disability is as relevant as it is to they're disabled, regardless of how they became that way. And let's use the special needs trust as a vehicle to give them the best quality of life that we can.
Yeah, so make sure I understand that one. So, I mean, whether or not, if you're disabled, that may be getting some benefits for you, and you're getting the benefits, so you want to set up the trust. But you can set up the trust probably even if you're not disabled, if there's other benefits you want to protect from. So
I think that's right.
Yes. To answer Lisa's question, you can absolutely do this if there's other needs-based benefits that they're getting.
Right. You said it far more succinctly, Rob. So you can tell who's the trial lawyer and who's the more long-winded attorney. That I need to be more succinct.
No, you're
Thank you.
doing great. Answer the questions fully. I want everybody to get their money. Go ahead, Kevin. Read the next one.
Well, there was a comment about a specialty a specialty bar of the Academy of Special
Yes.
Needs Planners. It was just more of a comment.
No, Thomas, I appreciate you bringing that up. Offhand, I was just thinking of the organizations.
Yeah.
Actually, I think we support all of those organizations. So it's the Academy of Special Needs Planner, what they call ASNAP. There's NALA, which is the National Association, I think, of Elder Law Attorneys, and then there's the Special Needs Alliance. Again, I'll repeat that in case anybody's taking notes. There's the Academy of Special Needs Planners, the National Association of Elder Law Attorneys, and then the Special Needs Alliance. If you're working with anybody that is a member of any of those organizations, I think you're probably in a pretty good, healthy space because they have focused their career to a degree on this space. And most importantly, they probably kept read into developments in their field that are relevant to making sure that whatever they're implementing is done correctly.
So you really want to look for those.
I think that's right. Yeah, if you're in this space and
you're
you're doing the planning. Yep.
Gotcha. All right. Okay, well, let's go to the next question. So somebody asked, how does Medicaid learn of an injury settlement? Self-reporting only? That's the question.
Yes, there's an annual reporting requirement that is through the Social Security Administration, where they're going to have to account for how the money was used and any changes in economics. I don't remember exactly the way they phrased the question, but underneath a response to has your economic situation changed at all in the last 365 days? And here you would say yes, but I put the money into a special needs trust, and you would give them a copy of that. I would say most practitioners, not all, but I've been with Forge for 14, almost 15 years now. And for 5 years, I was a practicing lawyer at a firm doing special needs work. And whenever I would set up a trust, I actually gave notice to the administration. And I did it by return receipt requested. So just as a little practice note there, I gave them a copy of the trust and I did it return receipt requested because that way then I validated the fact that the administration got it and they can't ever say you didn't give us notice. And it was a way of getting out of some bad situations where the administration tried to argue they never saw the trust. We'd say, no, there's the receipt. And that way then, Kevin, I didn't have to call you for.
Right. You don't want to call me. I agree.
I don't want to call Kevin.
I'm debating whether or not we even really want to be friends. So
that's right. Yeah. All right. So I'm going to jump around a little bit. I'm going to go to the top question. I don't know if you can see it, Peter, but I'm just going to read it. It says, I have a client that will receive policy limits. His net settlement will be about $142,000 or so. He's on SSI and Medicaid. He's agreed to a special needs irrevocable trust, has no family to serve as trustee, but has a friend willing to serve. We'd rather not have a professional trustee. What is an accepted compensation structure for the trustee service?
So I think it's Jeremiah. I don't know you from Adam, so I'm going to give you my honest gut response to this. And then, please take this for me just trying to be as supportive and helpful as I can.
Hold on. Now I'm just excited to see what you say next.
Jeremiah, I would be really reticent to put this in the hands of a friend. Because no matter how well-intentioned that person might be, they don't know the rules for how to administer. I'm assuming, again, maybe this person's a special needs lawyer, and if that is in fact the case, then you can ignore my comment. But if it truly is just a friend who has no prior knowledge of how to administer these trusts and the reporting obligations and filing of taxes and et cetera, I would just be worried. And I've seen too many scenarios that have ended negatively where people did the trust and it wasn't administered correctly, or money was frankly the trustee's going to have unfettered access to the funds, and they they have a bill that's running late and they mismanage the funds or start to pull money from the trust that's detrimental to the interest of your client. There's so many red flags that I see with having just a friend, so to speak, do this work that it gives me pause. If, in fact, this friend is capable of doing the work, I think the other question you've got to ask yourself is, do you want to create that dynamic between two friends where disabled person is now going to their friend for access to money? I always use it as a planning mechanism for when I'm dealing with families, generational wealth transfer, is I really advise ever against having siblings be the trustee of trust for their disabled brother or sister, because there's an emotional piece to that. And if as soon as you create a mechanism where now that sibling is deciding whether or not you say yes or no to a particular request, it's no longer a loving sibling relationship. It's now become a transactional one. And I think that's the same thing you'd see here, is that friendship could break apart if, in fact, that person said, no to a particular thing, but the beneficiary really wanted it. And so there's stress associated with that. And most importantly, I think this person who's disabled really benefits from that network of friendship. The emotional piece, in my view, of the disabled community is the people that can love and care for them around them. So taking friend out of that gatekeeper role, in my view, is probably answer number one. If you cut to a conclusion where you're still going to do it, totally understand it, then I think a reasonable level of compensation is generally about 1% for administration as it relates to the trustee's role. So 1%, times the assets that are in the trust times, divided by 12 each month they take it out. I think that's fine. Bear in mind, though, Jeremiah, is that trustee's then going to probably have to go see the money to invest those assets, and that's probably going to cost an additional 1%. So you're probably looking around 2%. An easier solution might be just working with a nonprofit. And if you want to follow up with me afterwards, happy to give you a direction to one. That nonprofit organization is going to be less than 2%. Is not going to have the emotional complications that I think your SPAC set might present. So there, again, Jeremy, I don't know you from Adam, so hopefully you're not taking that as a negative. I'm just trying to give you my honest assessment.
Yeah, and let me jump in. I had this happen at 15, 16, 17 years ago. I don't know. There was some period of time. It wasn't a massive amount of money. They absolutely insisted on a friend being. I couldn't talk them out of it. And the experience then that I have now. So they had a friend. It was a family member actually. Be the trustee, and it all went bad. We fixed it, but it all went bad. It all went bad for two reasons. One, because you can't spend it on just anything. Like, we gave them the paperwork, we gave them the booklets. Like, you can only spend it on this. We CYD'd ourselves, but they still spent it on things that they legitimately thought they could, but they couldn't because it's not unfettered. And then number two, it all got messed up because there came a time where they had to show receipts and documentation for everything, and they simply didn't have it. They were paying it out of different accounts, and they weren't keeping documents. And some things were like, "What's this for?" It says Target, like that's it. Because and so. It ended up, we had to go back a few years later when they started getting letters from the different entities that monitor these things, and we had to try to recreate it, and we had to do all that. We fixed it. It was a nightmare. I tried to talk them out of it and couldn't. So to the extent you can avoid it, I'm just giving you my personal experience. It ended up being kind of a nightmare that we fixed it, but I didn't like having to fix it. So anyways, that was...
All right. So, a couple of one's a comment, one's a question. I'll go with the question first and then the comment last. So the question is, money received by a client for his personal injury is not taxable as income, but it is considered income for government benefits eligibility purposes.
100% true. It is, the receipt of income for purposes of eligibility for means tested benefits. And then any growth on that, is going to be taxed. So even though the nut, if you take the lump sum, if you will, settlement, that money is not taxable under Internal Revenue Code 10482. But once that money is received and then invested, any growth on those resources, that will be subject to tax, regardless of whether they own it individually or inside of a trust. So just want to clarify that one particular point. Then, and I think that Shannon Conley's comment, so I'll let you, Kevin, go forth.
Yeah, the $967 cap says some states have SSI state supplements putting the amount received above $967.
So Shannon, I don't know what state you're in. That absolutely might be true. I've never seen it. But I'm gonna, for those in the audience, I think we get the benefit of always having dialogue with colleagues. So I'm confident that is true. And so I think it just reinforces, Shannon's comment is the way I'm interpreting is, even if you see somebody who has 967 or even a little above it, Kevin, they may be maybe they're getting 990, for example. That doesn't automatically mean, if I'm reading Shannon's comment directly, that they're not getting SSI, because they may be getting SSI plus that additional state supplement that is pushing them a little higher. So I think inevitably, as the practitioner, just understanding specifically what types of government assistance they're on is important. And so my final comment on that is, whenever dealing with this, one way to go and validate that is ask for their most recent awards benefit letter from the Social Security Administration. In that, it will either designate supplemental security income, or it'll just say old age retirement benefits or disability income. So it should identify at the letter level what type of program they're on. And that may be an additional way for you to be able to clarify what type of planning is needed for your beneficiary, or for your client, rather.
And we've got one more question that popped in. So I'll just, it looks like we have about a minute left. Can you go over when a trust or an ABLE account is needed for the needs-based benefits you discussed? You went over the eligibility requirements for SSI, but how about the other benefits?
And you can take a little extra time and thoroughly answer.
We're not bound by 450.
Yeah. So I would say that I think you're probably talking about like SNAP, like food assistance and Section 8 housing vouchers and the like. And I think what I would say is most of those benefits should be preserved by the utilization of a special needs trust or an ABLE account should be. I don't run into many scenarios where we are primarily focused on protecting the SSI benefit and the Medicaid benefit, and we never get any phone calls about the SNAP or Section 8 or whatever the case may be. And that might be due in part because many times we're buying homes, so the SNAP benefit goes away because they're going to own a home. But at least as it relates to rather the Section 8. But the SNAP benefits is a key component to a lot of people. Certainly, I think, Kevin, my assessment of it is that, this planning, whether it's ABLE or a trust, is going to preserve the form of government assistance that is, as long as it's being tested, is going to be able to protect that benefit. I say that with the caveat of being that I can't say that with 100% certainty. So it goes to show you that we all chose a career path where you constantly got to learn and do research. And so, John, my advice to you is, if you are looking at protecting other program benefits, just do a little due diligence, or the expert that you're hiring. Hopefully, it's me. If it's, we'll do a little due diligence to make sure that we understand the impact to whatever the government program might be, whether it's an ABLE account or a trust.
Great stuff. All right.
Kevin, I see did we answer the, Thomas, I think had a second one. I primarily rep pedophile victims. They're all depressed, anxiety, PTSD. I think that's probably similar answer to the
the disability related question.
So Thomas, we do a fairly, have historically, given just certain unfortunate incidences that occur across society. Your demographic of clients is one we have familiarity with. Oftentimes what you get into is whether or not the actual settlement dollars themselves are taxable, because there isn't if there's not a physical harm, so to speak, sometimes the IRS takes the position that sort of the intentional infliction of emotional distress is still taxable unless that it arises from a physical harm. And a lot of times, unfortunately, in these sexual scenarios, there may not be, quote unquote, the same level of physical harm present. I don't know your cases, Tom, so I can't speak directly, but we've seen that where we have to sort of navigate around that. But we do planning in that space, and anybody that that is able to do special needs planning could work through your scenario. And the biggest nuance is it taxable or not taxable? It's going to change. It's not going to change anything we've talked about. You're still going to go through special needs and ABLE account and everything else. It might change some of the planning in terms of investment strategies you consider, given the tax consequences of your particular set of facts. Not that we want to spend a lot of time on it. Taxable settlements, Rob, when you got a contingency fee, unfortunately, under the most recent Big Beautiful Bill or whatever they call it, I don't know exactly, it codified that the taxation of sort of a double taxation issue. When you have a settlement that is taxable in a contingency fee, the beneficiary's got to pay tax on the full amount. So if it's $1 million recovery, they pay tax on the full amount, and then they pay the attorney's fees, and then the attorney pays tax on their portion. So it's this unfortunate, double taxation scenario. And Thomas, in that set of facts, we do help analyze how best to get out of that, or at least mitigate some of that tax liability. And I think anybody that you're working with that understands the special needs piece should give that strong consideration if there is a tax piece to it. If the tax is not the issue, then all the planning we've talked about today is still applicable.
So one more question just for me.
Sorry, quick. Kevin, go ahead.
Oh,
sorry,
yeah.
Go ahead.
One real quick, Peter, does the One Big Beautiful Bill affect anything else you've talked about today?
Not that I'm aware of.
Okay. All right.
Yeah, not that I'm aware of.
All right.
Does anybody else have a question? You want to type it real quick? We can do a couple more minutes. Anybody else want to make sure everybody gets their questions answered the best as possible? Not seeing any pop up. I'm going to give it a few more seconds in case someone's typing. Looks like we're good. Matt, I really appreciate you inviting all of us to come down and do this. To our listeners, I really hope you learned something today. We tried to really focus in on the things that we look for. Peter and Kevin, it's always good to hang out with you.
Nice to see you.
Absolutely. Yeah. Matt, thank you. Kevin and Rob, sincerely, personally, thank you for the opportunity. We are greatly appreciative.
Thank you, Peter. Really appreciate it.
Thanks, everybody. Thanks, Matt.
Yeah.
Cheers.
Thank you all so much for sharing your expertise with us today. And I want to thank all of our registrants for attending today's program. I did go ahead and throw the slide back up on screen there, so you do have Peter's contact information, and that is also in the handout that was distributed earlier. Certificates of attendance and evaluation forms are going to be emailed out to live attendees within 24 hours, and we ask that you take a few moments to give us your evaluation of today's program. Our next Seminar Web Live program happens tomorrow. AI, Enhanced Advocacy, Extreme Time-Saving Tools for the Modern Trial Lawyer. I invite you to visit your association website for a list of other upcoming programs, and I hope that everyone has a wonderful rest of your day.
Friends, this is podcast producer Jim Ray. And as Rob mentioned, we are offering free CLE credit for this episode. So we are still waiting on the activity number. If you are an attorney and you would like free CLE credit for having listened to this episode, go ahead and just email Robert Mattingly. His email address is robertmattinglyattorney@gmail.com. Once we have the activity number assigned, we'll be sure to send that right over to you. As always, thanks for listening to this episode of the Legal Notepad Podcast.